Good afternoon, ladies and gentlemen. Today, we'd like to deal with the rest of torture in a comprehensive manner. I'm a little afraid if you may even lost of its basics. I hope that should not be the case for today. The topic we'd like to survey today is the tort immunity, defamation, intrusion of privacy, infliction of emotional distress, forced imprisonment, and special problems of economic harms. Before I begin the lecture, let me tell briefly the story of law people that have long been retrenched. And I'd like to provide an imagery that you can recollect to get fresh on my insipid narratives. I've consumed much time to surf on an internet site for those pictures. I might be condemned later as a frequent violator of intellectual property rights. Please accept my excuse. The first picture shows a high-tech worker who worked in the very much improved working condition other than the earlier stage of factory. The second scene and third one came from an artwork of avant-garde artists, where we can see a woman to stretch to the extremes of herself, and an image of Buddha who are indulged in TV. The last scene was a work of a deceased Nam Jun-pae. The fourth picture exposes a Roscoe Pound, who are generally considered a founding father of American legal realism. You may at least more than once be made with its name in many of classes, I suppose. The last picture discloses Hang De-han, who is the chief administrator of prosecution offices and now subject to public criticism on the institutional ethics and public aid trustship. We are kind of a seminar law society that the students and professors are concerned. The story is not only ours, but also one of issues that the public in general also occasionally shared to advise. It is also one of focus points that the 2012 presidential candidates promised to reform. I occasionally visit a nearby restaurant to have a meal where I can see most updated news. That is also the case of this morning, that the news reported that the court denied a petition to detain the failed prosecution officer. He was alleged to perpetrate an improper sexual relation with the suspect during the interrogatory process in his public office. We were actually shocked at these days' incidents on the serious corruption of AK.EDU, a prosecution officer, and sexual crimes of young prosecution officers. The recent public survey also rated the judiciary and prosecution attorneys as badly untrustful, which is contrary to a long tradition of reputable institutions in South Korea. In retrospect, however, the defective behavior of those institutions are not just the ones we experience today. Once the head of prosecution office was impeached on the basis of his bribery, and some of AK.EDU judges in the local court was also reported to commit a bigamy. This kind of misconduct cannot be said to be unique in Korea. As you are aware, a CIA director stepped down from his office recently, and a former President Clinton can be a leading example who was once subject to the impeachment for his sexual misdemeanor with Lewinsky. The public was so interesting to see a brilliant work of independent investigator named Starr. Actually, the petition of impeachment was denied in the Senate in the event, so we can suppose that a contingency can say much about the story of human nature. The case is we are now exposed to, however, seems serious, that the failed officer is young at earlier stage of his career, and the corruption of senior prosecutors are chronic, to raise some of suspicion about unethical or unlawful ties with the local portents. That suspicion was long held by the public at large, and we're now afraid if it is of a structured nature. Those unfavored elements on the case of a prosecution office are fairly foreseeable to militate with the current challenge from the presidential reform and also from the institutional reform strongly proposed by the national police. Along with the story of our neighbors, I drift of the identity of a contemporary citizen. Where are we standing now? Recently, I came across a report of sharp decline within the sector of national manufacturing industry. Most of our citizens are now not a part of the scene who work in the production line of automated process. The workers may differ in their appearance from the earlier stage of industrialization. In the factory scene of England in the 19th century, which brought the need to enact the Factory Act. In the context of Korea, many Korean workers have been exploring the hair-making factories, which are in 1970s, which are now valued to contribute to the current economic success of Korea. But now we just been echoed with the rare voice of extremists who struggle to reform the status of contingent workers. Do you agree if the egos in this contemporary society may be trailed with the aid of postmodern artworks? The working group are normally classed as avant-garde, which in some context is affiliated with a kind of a new intellectuals. What is avant-garde? From French, advance-garde or avant-garde. The French term used in English as a noun or adjective to refer to people or works that are experimental or innovative, particularly with respect to art, culture, and politics. You may make a proper recollection of the deceased Nam Jun-pae, was working on this line of artists. Avant-garde represents a pushing of the boundaries of what is accepted as the norm or the status quo. Primarily in the cultural realm, the notion of the existence of avant-garde is considered by some to be a hallmark of modernism, as distinct from postmodernism. Many artists have aligned themselves with the avant-garde movement and still continue to do so, tracing history from Dadaism through the Situationists to postmodern artists such as the language poets around 1981. So I now like to illustrate kind of avant-garde works to facilitate your understanding of our egos. Do you agree? Avant-garde. That's like most of common Korean people, particularly including me. I like to view a TV very much. If you are not the stable or high-tech workers, then you may take some time to retrospect yourself. This introduction is not just for the marginalized personality in the society, but in some sense may be affiliated with a kind of struggling leadership for change. We roll on the slogan for change, and that is the case now that we see through the Korean presidential election. The candidates, in many aspects, cannot but be contingent in nature, who are positioned at the forefront in the combat line, like the avant-garde. Let me say a bit more about the case of prosecution officers, who can be kind of a stable workers or high technician in the society. It could have, some colleague said, it could have been all right if they stayed to kill the time on TV, like the artwork of deceased Nam Jun-pae. But now the public seems to launch a fundamental question if the judiciary and semi-judiciary have to respect. Sang Dae-han's leadership are now on the public examination. Okay. As I first introduced, the fundamental ground of tort discourse in several countries may be found in several provisions of a civil code. In the Korean context, Article 750 of Korean Civil Code is a pivotal. All the code arguments and propositions are fundamentally resorted back to as its statutory ground. It is general, comprehensive, omnipotent, that the adjudicators in theory, not exactly in practice, of the intercultural change of legal practice are independent to find the true meaning of the statute provision. The recent Korean cow case, you may refer to the recent Korean cow case in the discourse Faroe. So we have seen some of differences between the civil and common law traditions, as I have stated in previous class. The dynamics in the legal system, therefore in theory, allows a breach of a stare decisis, principally held by the common law courts. Most typical example to safeguard the institutional integrity and line of formulating the national case laws in civil countries can be found in the clause, the lower court is bound by the rulings of higher court as a matter of law in that specific case, but as limited to that specific case. The appeal process, therefore, can ensure practically to enforce the law of higher court, and finally that of Korean Supreme Court. But it is not a pre-orienteering the judges at various levels. That the way of meditation can take his or own way, just being subject to the prescribed statutory word. So we can see the kind of exemplary incident named the Hwaengsung Hanwoo case, a Korean cow case, whose presiding judge severely launched an attack about the irrationality of a Supreme Court decision. There is also no job duty to investigate the precedents of same-level courts like the United States and other common law countries. One other aspect interesting to observe is that the court opinion of civil law countries gradually become shortened to curtail a vast of useful information that may lead to a future lessons. So I like to mention about the difference of both legal traditions, because this class is purported to get you understood about the basics of common law. The reform was actually undertaken in the context of Bangse judiciary around 1970 and 1980s in France. Now you can see two photos that may corroborate in one aspect, but I was unprepared to present the photos, which, sorry, you may be available in later case. Accept my excuse, please. I initially intended to excerpt a photo from a judge involved in Hwaengsung Hanwoo case, and some of the news stories about a judge who was stated, was attributed as one of a negligent officer. Now, for the case of France, which can be ascribed as one of original states for civil law system, more short court rulings, which is expected to include a conclusion, gist of logic, and a denotation of a applied statutes. But that kind of practice has been perceived as public good in a French context. That response can be properly understood. Such forms of judgment may more efficiently serve the uniform application of statutory laws. Public response from South Korea took a tone of antipathy, that the judge was viewed to neglect on his duty and frustrate the litigants. The abbreviated form of judgment also was once debated in United Kingdom, but with its practical change being negligible. Do you like to see the court judges who more resemble those of the administrative branch, like the French case? Then you can be more concise-served in some respect and may avoid the lengthy, sophisticated dealings about your matter. But in some cases, you may like to know the way of how your problem was addressed. For the unification of laws, it is largely accepted that the statutory system can be more effective, as defined in WTO or UN norms and agreements. But it is also noteworthy that the European Court of Justice and WTO dispute settlement body are crucially endeavoring to craft a body of case law that would perhaps be essential to establish a common platform for European Union, as like in the case found in creation of United States. Although not a sovereign creature without any people or territory, WTO is one of powerful international regime to control the trade issues, particularly because it provides a predictability and legal stability with a system of a dispute settlement mechanism. That achievement are now made for reinforcing with the intricacies of case law. Therefore, the manner of adjudication can, as a matter of course, differ under the given context. But as I have mentioned, the distinction normally conceptualized about two different legal families is now practically agreeing each other in some respect. Still delicate and in some cases even confronting is that the common law lawyers not in the least are grumbling about the short content in the law of civil law countries when he or she discusses the civil disputes of contract nature or a legal work as a legal aspect for uniform laws in the international negotiation. How do you prefer the mediated judges of Pangse judiciary and riding corridors? Have you minded on our constitutional theory that we even had just a couple of court opinions during so long as 40 years until the current Constitution of 1987? By way of instituting the special constitutional court, we now see a substantive body of rules of constitution backed up by the case regime of Korean Constitution. Now the constitutional scholar and jurors in Korea talk about the educational aspect of constitutional adjudication to orient the people in the right direction as a minded and intelligent citizen. Recently, the Korean government announced that the case law will be ready soon in English version, since we already complete on with the Constitution and other statutory acts. It would greatly propose that the laws of Korea to debut in the international stage. Do you agree? For some contrasting point, though, we may refer to a Dean Loskov Pound, UN cry, that the common law system now once faced a kind of heavy depression with a tremendous amount of case laws, long centuries compiled, that are now actually playing meaningless and insignificant, as if it were to be echoed, you may now frequently see some of compact essence of rules in the window page of Westlaw. And ironically, the status of distance in view of separate legal culture and intelligence was symbolically, in my personal viewpoint, addressed around 1949 when Dean Roscoe Pound collaborated with Hans Kelsen in providing a foundational work to create the United Nations. Who is Dean Roscoe Pound and Hans Kelsen? See? I've excerpted some of a Wikipedia page to introduce you to Dean Roscoe Pound. He has an interesting career path. His early life, let's see his early life. Pound was born in Lincoln, Nebraska, United States of America, to Stephen Bosworth Pound and Laura Pound. Very interesting, Pound studied botany at the University of Nebraska in Lincoln, and Nebraska, where he became a member of Acacia fraternity. In 1889, he began the study of law. He spent 1 year at Harvard, but never received the law degree. He received the first PhD in botany from the University of Nebraska in 1898. So he has a very unusual educational background to become a dean of Harvard Law School. Do you see any connection with the Department of Botany? May feel for Roscoe Pound to instill some kind of institutional inspiration to our law school. May correspond with the institutional point of study that the law are normally favored in theory and practice. In 1903, Pound became Dean of the University of Nebraska College of Law, and later began teaching at Harvard, and in 1916 became Dean of Harvard Law School. And afterwards, he took the path to become a law educator by working on many of legal products, including outlines of lectures on jurisprudence, the spirit of the common law, law and morals, and criminal justice in America in 1970. And he was normally attributed as one of very rigorous dean throughout the history of Harvard Law School. So, you now properly assume that both legal traditions may in many sense reach the grand compromise at that time. Upon that initiative, we may retrospect ourselves to impose a strength of others by enacting UCC, a restatement of torts, modeling after a civil code provision in countries, and so on. That is also the case now we now face in Korea, as I've stated above. And that is also kind of a situational, as you see some strengths of Pound's case. We usually refer to the German tradition, more intellectual and indoctrinating. But we sometimes emphasize a change and importance of contingency to transform a society. If you serve as a juror later, I'd like to advise you to be flexible on your career. Of course, that will also be true in other professionals. Many matters pressing us take a form of flexible nature, and the organization also needs to be adaptable. You may later make success as a leader of organization, and it is important to empower your lower class workers to realize a desired change. It is generally accepted to view the organizational dynamics as one of a biological creature, or the life science offers a useful tool to find the true nature of organization. If you are a chief administrator of court, or Harvard Law School, or the organization of Korea, how do you respond to the pattern of some court judges? And how do you respond to the quest of a public in South Korea? How would you problematize the Korean cow case, the judges of Korean cow case, or judges of unique style on its dealings? While the case arose in a limited context, it may provoke several points that we need to deliberate. How do you think if the court embody some of research panel to deal with the problems? How do you think if the prosecution office utilize a kind of conference of or convene the prosecution officers? Again, we now talk about the change and transformation in every sector of our society. The leadership is important to achieve a goal, and were presented many paradigms of leadership, such as contingent, situational, charismatic, a servant leadership, and that of managerial nature. Against the recent shocks in the judiciary and semi-judiciary, the civil voice may like to inquire seriously how to lead the organization. Presumably, most of the public may go disappointed to lose their trust and commitment with the court and prosecution office, previously held one of the most reliable organizations in Korea. They may find their icon of identification from some of avant-garde artifacts, which may seem a bit powerless or in solitude. How do you attribute yourself in the following three? As I've shown at the first class, high-tech worker in Samsung, Gyeong factory of Samsung, and workers in dated manufacturing industry and other images, including the work of a postmodern artist. Then how do you assess the trend of these days? The many of manufacturing firms now cease to turn their eyes to different type of modern business. The contingency is not just a matter of leadership and is related with many of our familiar words like contingency fees for the attorney and contingent workers now agonizing the labor union of Korea, and also can be one of a trace for realist politics, as Napoleon remarked. The contingency also work to demarcate to develop the case law, as we see in the matter of slavery in the United States. And as in the case New York Times and Sullivan later reviewed in this class, we also soon learned the doctrine of state immunity, that the state can do no wrong. However, that is not the law in its theoretical purity, which required many corrections and enabled a separate path of legal counteraction. For example, Korean people now have a State Liability Act. So I now start with some kind of narratives about the background and the current story of Korea, and I now propose to listen some amusing music, which is titled "A Canon," composed by Powell, and it may get you feel kind of a ordinateness or kind of a sacred and institutionalized. Okay? most popular music for the Westerners utilize it in the wedding ceremony. And for the class schedule, I may be required to get further even if the time is up. So I place the sheet as usual on the desk. So please don't interrupt the class progress if time is up. And you can prove your class attendance by simply writing down your name on the sheet. Okay. And we now briefly explore the tort immunity, including a intra-family tort immunity, a charitable immunity, a municipal corporations, a sovereign immunity, and official immunity. Most of rules came from a common law tradition, and also be deemed antedated of a vast scope of rules. So we start with a intra-family tort immunity. What about a parent versus child? Although no such immunity was recognized in the English common law, the early American decisions held that a child could not sue her parents, nor a parent her child for personal torts. That is also the case that we can see in the communistic context. Rationale. What is behind rationale? To preserve family harmony and parental authority. The immunity was recognized only as to personal torts. I never applied to bar causes of action by child against the parent for damage to the child's property. Of course, I have said the modern trend normally rejects this kind of immunity because of its obvious unfairness in many cases. The clear trend of authority today is to restrict or reject the concept of parent-child immunity. But even where abolished, courts do not permit actions by a child against the parent where the parent's act involves the exercise of reasonable a parental authority over the child or reasonable parental discretion with respect to providing a support or maintenance for the child. And you now see the context between husband and wife in immunity. The common law regarded the husband and wife as a single legal entity and accordingly provided the husband and wife could not sue each other for torts committed by one against the other, whether before or during marriage. Most jurisdictions today have rejected the doctrine of interspousal or tort immunity entirely and have denounced the common law fiction of a single legal identity for husband and wife. Some have abolished immunity only as to intentional torts, while others have abolished it as to all torts, intentional or negligent. The rationale behind this rule is liability insurance is so widespread today that the claim is really against the insurance carrier rather than against the other spouse. So there is no great danger to the marriage. In some cases, we see immunity is not applicable. Even an interspousal immunity has been retained, it does not apply in the following cases. Let's see, first, in the case both spouses are deceased. If A and H are both killed in a traffic accident caused by H's negligence, WZs are permitted to maintain suit against H's estate for the wrongful death of W. In such a case, the beneficiaries of W's estate are usually the same persons who are the beneficiaries of H's estate. And the action is really one in which the children are suing themselves. However, the cause tacitly recognize the existence of insurance in such cases and permit the suit. Let us consider the pre-marital tort. Either spouse may maintain an action against the other for pre-marital torts on the theory that because the tort did not prevent the parties from marrying, there is no reason to assume that the action will cause family discord. Even where still recognized, the doctrine of intra-family tort immunity does not extend to relationship other than husband, wife, and parent-child. Thus, for example, brothers and sisters can sue each other on any type of claim or cause of action. Let's briefly investigate the context of charitable immunity. A separate ground for tort immunity was recognized, a common law, for non-governmental charitable organizations and enterprises. This immunity is related in theory to governmental tort immunity. In other words, the notion is that the charity is working for the public good and should therefore be entitled to the same immunity as a public agency. Thus, it was held for many years that private charities, hospitals, schools, community organizations were not liable for torts committed by their agents or employees. Another rationale sometimes advanced for doctrine of charitable immunity is that funds upon which a charity operates are donated, and subjecting such funds to the payment of tort claims would be to divert the funds from the purpose intended by the donor. The doctrine is clearly on the wane today. It has been repudiated entirely in many states, with courts finding that any interest in protecting a good Samaritan is outweighed by the need to provide compensation to the Samaritan victims. Even when retained, the doctrine is riddled with exceptions. And let's consider the context of municipal corporations. A great deal of law has developed regarding the tort liability of municipal corporations, resulting from the dual character of such entities. On the one hand, they are subdivision of the state and therefore its agents in the exercise of certain functions and responsibilities. But on the other hand, they are also corporate bodies capable of the same acts as private corporations and having certain local interests not shared by the state at large. The law has attempted to distinguish between this dual character of municipalities and limits a tort immunity to the governmental or public functions. A municipality is a property or private functions are not immune and may therefore result in tort liability. The difficulty arises, of course, in attempting to determine which city functions are governmental, such as police and fire protection, and which are proprietary, such as transportation and utilities. So this kind of conceptualization is also found in the context of international law and is keenly related with the state immunity doctrine. In common law, the doctrine of sovereign immunity evolved that the king can do no wrong. Thus, when a plaintiff attempted to sue the state for wrong done to him, the state was held to be immune from tort liability. Whereas the government is liable or may consent to liability in suits of some other nature, its tort immunity is said to rest upon public policy. The idea that the people as a whole cannot be guilty of a tort. following this doctrine, it is usually held that not only are state and federal governments immune from tort liability, but so also various state and federal agencies, including hospitals, schools, and so forth. Most modern jurisdictions take the position that sovereign immunity applies only where an individual is suing the state. In other words, it does not apply where the state has sued the individual defendant, who then seeks to assert a counterclaim or offset against the state. In such a case, it would be unfair to allow the state to assert its immunity to bar the individual a defendant's counterclaim. Let's see the status doctrine in the context of contemporary times. The doctrine of sovereign immunity has been firmly implanted in our law and is retained in the majority of states today. Even so, the doctrine frequently operates harshly and equitably depriving injured persons of any right to compensation for torts inflicted upon them by the sheer coincidence that the wrongdoer was a governmental employee. Though some states recognize exceptions and others tend to reject it. In this context, one of the important point has to be given to the Federal Tort Claims Act. The Federal Tort Claims Act provides the subject to certain enumerated exceptions involving military and admiral powers and so forth. The federal government can be held liable in tort to the same extent as a private individual for negligence or other wrongful act or omission by governmental employees. However, the Act does not allow suit for functional intentional torts, strict liability, or discretionary acts by government agents. Discretionary is a pivotal term that we need to further in another class. And let's see the brief of official immunity. What about high-ranking officers? Judges, legislators, and the president are totally immune from tort liability for acts carried out within the scope of their duties, even if they involve malice or abuse of discretion. What about lower-level administrative officers? Lower-level officers or employees are immune from claims of negligence under federal law. Some states also follow this position. Let's see the common law rule. Other states retain the common law rule, which granted immunity to lower-level governmental officers or employees only when performing discretionary as opposed to ministerial functions. So we see the importance of distinction between discretionary functions and ministerial ones. Discretionary functions are those in which the officer has some element of a personal judgment or decision-making. For example, evaluating property for assessment purposes, or designing or routing a highway. In carrying out these functions, the officer is granted immunity as long as he was acting honestly and in good faith. Ministerial functions are those in which the officer is left no choice of his own. He is merely carrying out orders of others or established duties of his office. For example, repairing roads, driving vehicles. Here there is no tort immunity. If the officer fails to perform his required duties properly, he can be held personally liable for any damages resulting therefrom, regardless of whether he was acting in good faith. I must stop here, although we are left with many banknotes. That will be for the next class. I promise to facilitate the discussion in the next class. That will be all. See you next week.